got some motherfucking design on right now. Bring it down, bring it down, bring it down. I got 3 old thoughts to the
Back on the record in state versus Davis. 2502389 FY, Mr. Marchmina, Mr. Freeman, Mr. Davis are back before the court. We're at the point where the proofs have ended and Mr. Marchmina and Mr. Freeman, we're getting ready to make arguments. We shall begin.
Apologize in advance. Obviously, it's been a very long day already. Already a lot of counts, and my hope is that there will be several more counts. I will start obviously with what's there. We have count 1, unlawful imprisonment, which I believe is instruction 19.8. I will hop over there. First, the defendant knowingly restrained another person. Restrain means to forcibly restrict a person's movements or to forcibly confine the person so as to interfere with the person's liberty without that person's consent or without lawful authority. Now, in this case, we don't have an overt, oh, you're trying to leave, I'm grabbing your arm, pulling you back in. But I would submit that there is forcible restraint and forcible confinement, in that force was used against Ms. Iwahara repeatedly, into the night. And then the one point when she did step out and then come back in, he's got a bat there, ready to hit her with the bat, sending a very clear message, you're not allowed to leave. So when you look at the whole transaction, the beating followed by her stepping out for a second and saying, well, I thought it was okay for me to leave then, and him having a bat, it's very clear that she was forcibly restrained inside of this house. And obviously, you have exhibit 2. He doesn't even have lawful authority to be at this apartment. So obviously he had no lawful authority to restrain her in this apartment. Did so under let me see the circumstances under which it's charged. It's charged in a number of theories. By means of a weapon or dangerous instrument. Well, he used a baseball bat at one point to restrain her there. To facilitate the commission of assault with intent to do great bodily harm. Well, we're obviously going to get to assault with intent to do great bodily harm, but he's keeping her there so that he can beat her. And to facilitate interference with the crime report. Well, he wants her there so that she can't go to the police and get help. And there's a whole litany of crimes that he is restraining her to commit. And obviously, just as a background matter, we established venue, we established ID. So I do believe that we have probable, let me take a quick look over at a number of theories. We have probable cause to bind over on count 1, unlawful imprisonment. I anticipate that if there's an element that he fought on, it'd be the restraint element, because there was never a point when he tied her down and said, okay, you can't leave, but there was physical force used against her throughout this encounter, and that is the force that kept her in the apartment. Now, count 2, assault with intent to do great bodily harm less than murder. This is charged as great bodily harm. It's not charged as strangulation. This one clearly speaks for itself. I'm going to pop over to 17.7. Tried to physically injure another person, had the ability to cause an injury, intended to cause great bodily harm. This speaks for itself. He is punching her in the face repeatedly. He is kicking her. He's punching her body. He's pushing her from behind. We saw the injuries. The injuries speak for themselves. The evidence speaks for itself on count 2. And so I would ask the court to bind over on count 2, assault with intent to do great bodily harm less than murder. Now we have count 3, interfering with crime report, committing crime, threatening, kill, injure. So I believe that right here we have instruction 37.8A. Now this is one where 37.8A, I'm going to use the complaint for assistance here because the jury instruction is kind of messy. Through the unlawful use of physical force, prevent another person from reporting a crime committed. Well, he clearly used physical force to prevent Austin Iwahara from reporting all of these crimes he was committing. He was, again, this is kind of the same logic as the unlawful imprisonment, is all of the violence that he had done made it clear to her, if you report this crime, there will be more violence. And then we also have the instance in which she left and came back, and then he has the bat. And the violation involved committing or attempting to commit unlawful imprisonment or interfering with electronic communications. So the unlawful imprisonment we discussed, he was unlawfully imprisoning her, and there was testimony from Officer Uberith about how, the topic of the police and her not going to the police came up when she came back into the apartment and he has the bat. So this unlawful imprisonment component is facilitating the interference with crime report. And then also the interference with electronic communications. Well, there's evidence of him withholding her phone from her in order to prevent her from reporting a crime or threatening to kill or injure. In this case, there's no evidence of an explicit report a crime, I'll kill you, report a crime, I'll injure you. It's very much an implied threat from the fact that he had been beating her, that he had been holding her hostage, essentially, that he had been threatening her with a bat. So all of that pieced together amounts to threats to kill or injure Austin Iwahara in order to keep her from reporting all of these crimes he has committed. Moving on, so I would ask the court to bind over on count 3 as well. Moving on to count 4, interfering with electronic communications. I have that down as 35.1. First, the defendant prevented, obstructed, or delayed by any means the sending of an authorized communication through any electronic medium of communication. It does not matter whether communication was actually sent to the scene. Well, we have testimony. Obviously, Ms. Iwahara did not remember things well when it came to her phone. What happened with the phone, she didn't remember it well. She gave a statement to Officer Uberith immediately afterwards, and Officer Uberith repeated this testimony. Basically, he took her phone and was very explicit. You can't use this phone to call the police. Did this willfully and maliciously. Means that the defendant did the act on purpose with the intent. And it's very clear from the evidence presented that he took her phone with the purpose, the intent to keep her from calling for help. That was a theme throughout this. He doesn't want her getting help. So I would also ask the court to bind over on count 4. Now, count 5 is child abuse 4th degree. That, of course, is a misdemeanor. I think they called that a tag-along count before. Then we have count 6, domestic violence. Now, we're going to circle back. It's going to sound weird. I'm going to ask to dismiss count 6, and we're going to come back to that later. And that's what we have on the complaint. I'm going to ask for an added count 7, 1st degree home invasion. And the instruction there is 25.2C. It's what I'm going for. There's a number of theories in which you can get 1st degree home invasion. The first thing I would highlight is, obviously, I brought you some case law earlier because this is his home. Well, he had no legal right to be in the home. The courts have spoken on this. You can't say, how can it's not home invasion, this is my home, because the evidence is clear. He was not legally allowed to be within 2,000 feet of this home. And so the without permission element is satisfied. The law is clear on that you can have home invasion of your own home if a court order says you cannot be in that home. So circling back to instruction 25.2C, first element, entered a dwelling without permission. Entered the dwelling. First off, Austin Iwahara could not give him permission to enter the dwelling. It's not clear from her testimony whether or not she did, but with Officer Uberith, he indicated that the defendant walked in and then she immediately was like, get out, you can't be here. Regardless, he did not have a legal right to be in that home. He did not have permission to be in that home because there was a bond condition from this court saying you are not legally allowed to go within 2,000 feet of where she lives. And that's where she lived. So without permission element is satisfied. Second, when he entered the dwelling, he intended to commit we're going to go with an assault. The evidence of his intent to commit an assault is apparent by the fact that he went in there and immediately assaulted her. The testimony is that he goes in, she turns around while holding a baby, and he runs up and pushes her, and that's how it starts. B, that when defendant entered, was present in, or was leaving the dwelling, actually committed the offense of assault. Evidence left, right, center, all over the place. He committed an assault while he was in that dwelling. Third, when the defendant entered, was present in, or was leaving the dwelling, either of the following existed. Well, we can get this under either one. Was armed with a dangerous weapon. Well, at one point while he was in that dwelling, he was holding a baseball bat. He was armed with that bat, using it as a weapon. Another person was lawfully present in the dwelling. Austin Iohara was lawfully in this home. It was her home, which is why he could not be lawfully present in it, regardless of what it says on the lease, regardless of the keys he has. He had no right to be there. And so I am going to ask the court to add count 7, first-degree home invasion. Now we're also going to ask for count 8. Let me find the exact title for it. Interfering with witnesses in criminal case. That's instruction 37.5A. This, of course, is going to come from the phone calls that we listened to, where Ms. Iohara was able to identify both the voice of Mr. Davis as well as his father, and it's clear from the context that it's Mr. Davis talking to his father. Now, in these calls, he thinks he's clever because he never actually says her name, but it's pretty obvious. You don't have to be a rocket scientist to know that he was talking about Austin Iohara and trying to keep her from testifying. I believe some of the words he used were, Dad, just talk to her, try to talk her down, bring her down. Very clear that he is directing his dad to go talk to her and keep her from testifying, because he said at one point, this all goes away, and it all goes away. All right, we're gonna buy a house together, and I'm gonna have to spend all this money on legal fees. This all goes away if you can get her not come to court. Getting to the elements, Austin Iohara was an individual who was going to testify at a future official proceeding, including a judicial proceeding. For official proceeding, authorized to hear evidence under oath. Okay, she was going to testify here today. Defendant impeded, or, well, let's go to the attempt, or tried to impede, interfere with, prevent, or obstruct this person. Doesn't matter if the proceeding took place, as long as they knew or had reason to know that they could be a witness at the proceeding. Speaks for itself. Knew that she was going to be here to testify, and he tried. We don't have to have, we had testimony that was, skillfully elicited on cross-examination about the fact that there actually was no contact from Mr. Davis's father. He didn't come and try to keep her from knowing. So there never was success in this interference, but trying to. He is on the phone desperately trying to interfere with this individual's testimony. Defendant intended to impede, interfere with, prevent, or obstruct this person from attending testifying it. Made it very, very clear that's what he wanted. He wants her to not show up. The official proceeding was a criminal case where a crime punishment was more than 10 years was charged. Well, he's charged with unlawful imprisonment, which I believe is a 15-year. It is a 15-year. And so I am going to ask for an added count 8 of interfering with witnesses in a criminal case. Now, I'm also going to request count 9, strangulation. That is 17.35. Assault by strangulation or suffocation. First, defendant committed a battery on Austin Iohara. There's evidence of that all over the place. Touching was intended, speaks for itself. Battery committed by strangulation or suffocation. Well, this Iohara testified that he put his hands on her neck and squeezed until she lost consciousness. That is a near-death strangulation right there. And so I think that the evidence speaks for itself on request for count 9 strangulation. So I would request the court find this over on an added count 9 strangulation. Now I'm also going to request that the court add count 10 felonious assault. That is instruction 17.9, also known as assault with a dangerous weapon. Defendant either attempted to commit a battery or didn't act that would cause a reasonable person to fear, apprehend, an immediate battery. We're obviously going under assault theory. It's a baseball bat, right? I mean, I think you know where this is going. He's holding a baseball bat like a baseball player, like he's about to swing within distance with which he could hit her with this bat. And she was terrified he was going to hit her with the bat. I think it speaks for itself. And it's clear that he intended to make her fear. Like, why else are you going to hold a bat up to someone? You want to be afraid they're going to get hit with the bat. And the dangerous weapon is the bat. I don't think that we can argue in good faith that in this context, the bat's not a dangerous weapon. Had the ability to commit, appeared to have the ability, well, he's standing right by her with a bat. He had the ability to hit her with the bat. And so I am going to ask for added count 10 felonious assault. And now finally, circling back, I asked to dismiss count 6 domestic violence. And I am instead going to ask to add count 11 aggravated domestic violence. The difference, of course, being the existence of an injury. I'm going to go to 17.2a. First, I mean, we have evidence all over the place of this assault. So I'm not even going to get too deep into first. Second, there is a lot of options here. We have 3C, child in common. 3E, previously had a dating relationship. 3D was a resident or former resident in the same household. So we have clearly this domestic relationship element satisfied. And then finally, the assault causes serious or aggravated injury. Well, she came in with a nose guard on, right? Because he broke her nose. And we also had pictures of her having lost a tooth. It's clear that we've established. And as far as immediate medical treatment, well, she went right to the emergency room. Disfigurement, impairment, or they caused disfigurement. I think you could say that she looked disfigured in these pictures. She couldn't even open her eyes. So there are a number of different ways that we can get to the injury element of aggravated domestic assault. And so I would ask for an added count, which obviously is a misdemeanor, but it wasn't there already. So I would ask for a count 11, aggravated assault. The dismissal of count 6 is only if you do. So if you're not persuaded that the facts warrant aggravated domestic violence, then I would not want to dismiss count 6. So in sum, we're asking to find over on count 1, unlawful imprisonment, count 2, assault with intent to do great bodily harm, count 3, interfering with crime report, count 4, interference with electronic communications, count 5, misdemeanor, 4th degree child abuse, count 7, first degree home invasion, count 8, witness interference, count 9, strangulation, count 10, felonious assault, count 11, aggravated domestic violence, and dismiss count 6. Thank you.
Mr. Freeman.
Thank you, Your Honor. For the record, the defense objects to the bind over of any of the counts or all of the counts, but in particular, I would be pleased to start with counts 3 and 4. I think that they are similar enough. It indicates that my memory of the evidence through this testimony of the alleged victim here was that he verbally indicated to her not to call the police or not to call anybody, but that was not accompanied by through the unlawful use of physical force. The evidence is that there was unlawful physical force, but it wasn't in connection with the phone. My memory is that she passed out more than once. She said she lost consciousness. And she then said that she was woke up the next day or woke up the next morning. I don't believe it's even reasonable to suggest that she was in need of her phone when she is either asleep or passed out or what. She said she woke up the next morning. So I understood the argument, but I'm not convinced that they were in the correct chronological order such that they would meet the elements of that statute. And that argument goes for count 3 and count 4. Did willfully, maliciously prevent, obstruct, or delay? I think the witness testified that she simply had, and I'll let the court rely on its memory, but she either misplaced or lost, or she didn't know where her phone was, but that she certainly had it when she went to the neighbors. And I understood that to be the next day, August the 5th of this year. The count one, unlawful imprisonment. Counsel was quick to remember that the testimony was that the defendant had a weapon by way of a baseball bat. I'm not arguing that it is not per se a dangerous weapon, but it certainly, depending on its use, could be. So I'm not arguing that it's not. But my memory is that this baseball bat testimony came after she had gone out with the dirty diapers and had come back into the apartment. All of the behaviors that would constitute restraining her occurred before we saw the baseball bat. So it wasn't by means of a weapon that he restrained her. Felonious assault, sure, but it doesn't qualify for unlawful imprisonment as it's worded here. I heard no testimony that he threatened to kill or injure her. And I do not understand any theory that suggests that this defendant knowingly restrained Ms. Awahara in order to facilitate the commission of assault with the intent to do great bodily harm. Even if the court finds that by probable cause that crime occurred, I don't see that there's a connection that he knowingly restrained her for this purpose of committing an assaultive crime. The counsel has asked for the addition of count 9, strangulation, 750.84. I would gently remind the court that 750.84 is essentially comprised of two separate statutes. One is 750.84, the traditional assault with the intent to do great bodily harm, less than murder. And the second is assault by strangulation or suffocation. And the appellate courts in this state, with published opinions that I regret I don't have with me, have indicated that it is not proper for a defendant to be charged with both, that the prosecutor has to pick his poison. Either it was assault, strangulation, or it was assault, great bodily harm, but not both. If the court believes that there's probable cause to find this matter over on count 8, essentially witness intimidation, I concur with the comments of the prosecutor that it would be an attempt only. I believe, yes, I'm arguing count 1, 3, 4, and that the prosecutor must choose between count 2 and count 8. With my thanks to the court.
I think one thing I would clarify is that the great bodily harm and the strangulation is referring, like the strangulation is referring to the specific act of strangling her, whereas the great bodily harm refers to more generally the beating and the punching and the kicking. That's just one clarification. Aside from that, I think that the court has heard enough from me, and you've seen all the evidence and you've taken diligent notes. So I will just defer to the court at this point.
Thank you. The court must decide at preliminary exam whether there's probable cause to believe that felonies occurred and probable cause to believe whether this defendant is the person who committed the felonies. The court took testimony today from Austin Iwahara and Bailey Uberoff, provided testimony. I guess firstly, starting with Austin, identified our defendant, Dean Davis Jr., as the person about whom she was making these accusations here in court. And the testimony provided that this occurred on or about, it looked like August 4 to August 5th, 2025, at a location on North Sycamore Street here in the city of Lansing, making venue appropriate in this court. Mr. Marchmina spent a good amount of time on going through each jury instruction because he knows that that's what the court does in making a decision about whether each element has been met, at least to a probable cause standard. First, for count one, the defendant must have knowingly restrained another person. Restrain means to forcibly restrict a person's movement or forcibly confine the person. I noticed that the description says forcibly restrict. It does not say use of physical force. It just says force, which is different than the language the legislature chose for count three, which requires a physical force. In this case, I find that Mr. Davis did restrain Ms. Iwahara when she exited the residence, which I think she testified she felt afraid to do, but once she felt like she could exit to do trash, when she came back in, Mr. Davis was standing there with a baseball bat and holding it in a threatening way that she thought he was going to hit her with the bat. And testimony of Bailey Uberoff was that when Austin provided her statement at the hospital, she said that Mr. Davis actually said that she wasn't to leave again. That would be a restraint by force, as he was holding the bat in a threatening manner and using threat against her in order to get her to stay present in the residence. Second, the defendant did so under one of the following circumstances, and I will say it's most easy to find the element of restraint by means of a weapon or dangerous instrument, because he was clearly standing there with the bat when he told her she could not leave again. I do think it is a little bit harder to say that he did that to commit an additional felony, because most of the events, it's difficult to get a timeline. Austin's memory of the events wasn't great, but that's to be expected after the type of described event and the amount of physical injury that she displayed in the exhibit. That, you know, the fact that she doesn't remember is not being held against her, but the court is considering the supplemental testimony of Bailey Uberoff in that he was able to get more information from her close in time to the event. So it seems like by the time that Mr. Davis is standing there with the bat telling her she can't leave, he's already taken her phone at that point. He's already beat her. And then as for the interfering with a crime report, I'm not sure the elements are there on that one. So I'm going to say I bind over on count one, but it's basically on the theory that the unlawful imprisonment occurred by means of a weapon.
Can we subpoena her phone records and my phone records to prove my innocence? I don't know how else to go about doing this. I don't have the means to subpoena the records, but we can prove the phone records that I never took her phone with the phone calls, texts, and also that I did not enter the residence unwillingly.
That's something that it's not about unwillingly.
I've been living there for the months.
And you're under court order not to be there.
That's I understand.
And I still have to make a decision about whether you're violating my bind. So stop talking about that right now.
But can we subpoena the court records? How do I go about doing that?
Your lawyer can decide if they want to try and obtain her phone records.
Our phone records, both of them.
As for count two, the request is for assault with intent to do great bodily harm less than murder. Primarily, the defense's argument is that they can't charge strangulation and GBH at the same time. I would suggest that that might be true if they were trying to use one singular act to charge both different theories. But in this case, the prosecution is alleging different theories. It would not be a just interpretation of the law to say that the prosecution is limited to picking between strangulation or great bodily harm when both different events occurred at different times during this transaction. So therefore, I guess I don't find that they can't have both. For count two, it's first the defendant tried to physically injure another person. The description of events and the exhibits that were displayed to the court show that Ms. Iwahara was bruised. Her face was swollen extremely. Her eyes were swollen. Her tooth was missing. And she said the defendant is the person who inflicted those injuries upon her. That shows probable cause to believe the defendant tried to physically injure her. In fact, I will note for the record that the defendant admitted in one of his jail calls, at the very least, lumping her on top of her head, which is an assault, is an intent to try and physically injure her.
She has been missing that tooth since I've known her, and she's missing her whole top row because she's been a meth head. So, I
Mr.
mean,
Davis?
if the root has been healed, I
Davis?
obviously didn't knock that tooth out.
You think the tooth is the only problem here?
No, I'm just saying there's
Okay.
multiple lies being told. And I'm just-
Second, at the time of the assault, the defendant had the ability to cause an injury, or at least believed he had the ability based on the displayed injuries to her body. There's probable cause to believe he had the ability. And third, the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there was an injury, it can be considered as evidence of intent. Great bodily harm means any physical injury that could seriously harm the health or function of the body. The extent of the bruising to Ms. Iwahara's body shows an intent to do great bodily harm. Extreme bruising can actually cause quite serious medical complications. And so I find there's probable cause to bind over on count 2. As to count 3, I find that to be a much more difficult charge to find probable cause, because it requires, hold on, right here, 37. It requires the defendant use physical force to prevent her from reporting the crime. At the time that it appears that he's preventing her from committing the crime, it doesn't seem to be that at least the description of the events that we could get from Ms. Iwahara and from Bailey Uberoff don't lead the court to believe that there was physical force used to prevent her from committing the crime. There's a really bad beating, there's a strangulation, there's slamming her head into the wall. She wakes up on the bed. It's not clear when she goes outside and is told by Mr. Davis that she's not to leave again, and he has the bat. It seems like that is after all those other events, but I don't think that the brandishing of the bat is going to qualify as physical force. So the court declines to bind over on count 3. Count 4 is interfering with electronic communications, or as we call it, telephone interference. In that case, it requires that the defendant prevented, obstructed, or delayed by any means the sending of an authorized communication through a telephone line or electronic medium of communication. Ms. Iwahara said she did not have her phone. She wasn't really clear on what had happened to her phone. Only the testimony of Bailey Uberoff says that she claimed that Mr. Davis had taken her phone. She did say to Uberoff that this was done to prevent her from calling for help. Although she did obtain her phone again, it wasn't clear when that was. It was somewhat suggested it might have been after she woke up the next morning on the bed, after she says she had lost consciousness. So the court accepts Bailey Uberoff's testimony that the defendant had taken her phone to stop her from making a 911 call. And then second, the defendant did this willfully and maliciously, meaning he did it with the purpose to prevent or delay the communication, which is exactly the testimony that Bailey Uberoff provided. The court will bind over on count 4. Count 5 is a misdemeanor. The court makes no specific findings. The prosecution has moved to dismiss count 6. So count 6 will be dismissed. Count 7 is the request for the home invasion first degree, which requires first the defendant entered a dwelling without permission. The court has been provided with a case of People versus Hardenberg, which is a June 11, 2025 case. It's the only reason I can imagine you pulled this case instead of one of the many other copious cases that are cited. It's an unpublished opinion, 2025 Westlaw 1659216, but it cites to numerous published opinions that says an individual may commit a home invasion of his own dwelling if the individual has lost the legal right to enter the dwelling, such as through a court order. And it cites to numerous published cases, such as People versus Dunnigan, 299, Mishap 579. Cites to People versus Pohl, 202, Mishap 203. And it says, cites to People versus Zapara, SZPARA, 196, Mishap 270, which all support the theory that if a person is barred from entering the residence that and they go in, they can be entering without permission. In this case, the issue was a jury instruction that was given, took out the part whether the owner could give permission, because this wasn't about whether the owner gave permission, it was about the court order, which is our case here. So first, the defendant entered a dwelling without permission. I find that there's Exhibit 2 that shows that Mr. Davis is prohibited from entering within 2,000 feet of where Austin Iwahara lives, works, or goes to school. And Austin Iwahara stated that she lived at the North Sycamore address when Mr. Davis entered. That would give the court probable cause to believe that Mr. Davis entered in violation of a court order, which is without permission. Second, that when he entered, was present, or was leaving the dwelling, he committed an offense of, and is assault GBH, soon to find out, assault strangulation, felonious assault, unlawful imprisonment. There's a list of offenses that he committed while he was there. I'm not going to entertain the idea of whether he intended to commit those at the time he entered, because maybe when he entered, he didn't intend to commit them, but as soon as she told him to get out, that's when those things happened. But that when he was there, he did commit those offenses. And third, that when he was in the dwelling, there's probable cause to believe that another was present. Both Austin Iwahara and his child, Borgard, were present at the time the offense was committed. So there's probable cause to add home invasion, first degree. And I need to grab a path code for that. 750 110A. There's a request to add interfering with a witness, which is based on the phone calls that were made. 7.5A. We heard phone calls here today that were admitted as exhibits wherein Ms. Iwahara identified Mr. Davis's voice on the phone calls and that he was speaking to his father. And I believe he references the other person on the end of the phone, at least in call number 2, as his father. First, that Austin Iwahara was an individual who was going to testify or going to provide information on ongoing future proceeding. There is another case, as we know, and that was where the bond order was entered. So it's in Exhibit 2 that there's another case, 2501864SM, where Austin Iwahara was named as a person who was going to testify. And within our own case here, 2502389FY, Austin Iwahara is named as the complainant and was going to testify. Second, the defendant, and it says impeded, but it also says, or tried to impede, interfere with, prevent, or obstruct Austin Iwahara. He was not successful in stopping Ms. Iwahara from testifying in court. It is clear from those phone calls, he told his father to call her, to talk to her about money, to talk her down, to tell her that he was going to get life in prison. All of that was an intent to impede, interfere with, prevent, or obstruct Austin Iwahara from showing up at court. Third, the defendant intended to do that impeding of Austin Iwahara from testifying. He was quite clear during those phone calls that that was what he was intending to do. And fourth, the official proceeding was a criminal case charging the crime with a maximum punishment of more than 10 years or life. And in this case, specifically, he was referencing the unlawful imprisonment charge, which is punishable by 15 years. So the court will add the count 8. Count 9 is a request for assault by strangulation. As explained earlier, I find that because the theory involves a completely separate act from the beating and bruises that she had, that an additional count of strangulation could be appropriate. Ms. Iwahara specifically testified she was strangled until she lost consciousness. First, the defendant committed a battery on Austin Iwahara. Second, the touching was intentional, not accidental and against her will. There was nothing in the testimony to suggest this was an accidental strangulation or that it was consensual. And third, the battery is committed by strangulation or suffocation. The court will add count 9. There's a request to add a count 10 for felonious assault, that being assault with a dangerous weapon, the baseball bat. As the court has already made specific findings that the defendant brandished a baseball bat and told her she could not leave. Appears that the defendant did an act that would cause a reasonable person to fear, apprehend, an immediate battery. The defendant intended either to injure Austin Iwahara or make her reasonably fear an immediate battery. And that's how she said she felt, that she feared he was going to strike her. And third, that he had the ability to commit a battery, appeared to have the ability, or thought he had the ability. And the testimony is he appeared to have the ability, as she thought he could strike her. And fourth, the defendant committed the assault with a dangerous weapon, that being an object that was being used in a way that is likely to cause serious physical injury or death. The court will add count 10, felonious assault. There's a request that in lieu of the count 6 to add an aggravated domestic violence. The testimony was about the domestic relationship between the parties. Ms. Iwahara testified that they have resided together. They have a child in common. They've had a dating relationship.
Excuse me, Your Honor, is this a misdemeanor that the court is?
It is, but because probable cause was not found in the original affidavit, I have to make findings now.
Thank you.
Thank you. And that there was battery, forceful, violent, or offensive touching of another person. And even though that some of the conduct overlaps with the assault GBH or the assault strangulation, this offense can be added because it has the additional element of the domestic relationship. So it is not considered a lesser included offense. So I find that there's probable cause to believe the defendant committed battery on Austin Iwahara, that there was a domestic relationship, and that the assault caused a serious or aggravated injury. Ms. Iwahara went to the hospital, and she also mentioned having surgery on her nose as a result of the event. That would be an aggravated injury. The court will add a count 11. Sure, I read this down correctly. I'm gonna need some PAT codes probably. I got the got home invasion. I grabbed that one. Let's say 1227A. Is that what that's supposed to say? Yes.
I assume so. Even when I try to write well, I read it.
Right all the time. All right. Fine. Over circuit court. When we were here last time, I established a bond for Mr. Davis of $500,000 cash surety based on the testimony here today and his inability to manage his behavior half the time. About half the time. I'm going to keep bond the same.
Apologize for my behavior. I'm just facing multiple charges I'm not guilty of. I can prove my innocence and I will prove my innocence. So I'm gonna apologize that it makes me never been in this situation.
Mitchell fourth offender, sir. Half. Okay. I'm going to sign the bind.
After charges of this.
I see. I see the distinction. Okay. If you would like a transcript, be sure to see Ms. Geesing or anything else for the record for Mr. Davis.
Not for people.
Nothing further from the defense, Your Honor. Thank you.
Thank you. Mr. Marchini, you can have your exhibit back. Oh, yeah.
Do we have Mosels?
Let's just adjourn it to September 8th.
Okay.